What up, everybody? Welcome to the channel. If you're new, don't be. Go ahead and click that subscribe button to be a part of the Witness gang, to join the Witness Nation. Now let's get into this, shall we? Hello, you guys, and welcome to the channel. If you're new, don't be.
I'm Whitney. Keep it cute, get the boo.
Your girl, as whack as she is in all her glory, was in the New York Times. All right. Hello, everybody. Welcome. Okay. Usually I get into my whole little spew and I tell y'all what up and welcome and stuff like that, which I'm going to get in the chat real quick, but time is a ticking. Time is of the essence. Okay. So first and foremost, shout out to Mary Blue in the building. Hey, honey bunches. And Miss Kelly Rogers. Hey, hang in there with me. We're still waiting on the government response, but I'm going to tell you why. Ha ha ha. The government is about their biz naives. Okay. Hey, Shawty, I got you at the end of this live. All right, you guys. Okay. So just in, as we are highly awaiting for the government's response, I'm telling you, okay? I told you guys the other day, y'all gonna listen to me one day. I said that that we still have to wait on Bojangles. The reason why it got pushed to today to begin with is because of Bojangles. They needed more time. And because the judge is fair, she extended it to the government. What did that mean? It gave the government more time to see exactly what more Bojangles is going to submit. We're not going to get a response back anytime here soon. I say closer towards the end of the night, 11, right at the cusp of it becoming midnight, before becoming another day. I believe that we will see from the government, okay? I don't think it's going to be anytime soon, okay? But you know, what do I know, right? Okay? But I'm just telling you guys because I haven't steered you guys wrong, okay? So again, the defense just submitted the rest of their information for the retrial. I told you guys that Bojangles asked for an an opportunity to have an extension to be able to submit more information. So this is what she submitted. Okay, let's go ahead and get into this because I'm not going to wait any further because we're waiting on the real hardcore stuff, and that is the response from the government. Okay, so I'm just going to go through my little titles real quick. Okay. All right. If you would like to support and donate to the channel, here it is right here. Okay. So let's go ahead and get into this. All right. Let me go ahead and I'm going to share my screen. All right. Okay. Now, those that are tuning in again, okay, let them know as they're tuning in that we are just trying to hear. Hold on. Where did it go? Okay. We are here to hear what's her face? Bonjangles had to say. Okay, I got it pulled up. All right. Okay, this is the remaining half. Okay, this is the remaining half. Okay. All right. If you guys can share this video, please. Okay. All right. Let me get my watermark. That's for sure. Okay. And I'm going to put myself down here at the bottom. Let me take this off of the screen. Okay. I'm trying to work as hard as I possibly can for you guys. Okay. All right. So let me go ahead. I was over here twisting my hair and I've just been refreshing the daggone screen. Okay. So let's go ahead and get into this read. Okay. All right. Again, this is Bonjangles' remaining response. Now it's really in the hands of the government. But I knew the government wasn't going to move until they got all of what Bonjangles is claiming. Okay. So here we go. Okay. All right. So as you guys see here, this was just submitted. Today is the 21st. This was just submitted. Okay. And it's United States versus Robert Sylvester Kelly. And it says defendant Robert Kelly's notice of supplemental motion for a new trial. Remember, she had to add more information. This is what it states. Okay. It's 14 pages. We're going to read right through these. Okay. Please take notice that upon the accompanying memorandum of law, defendant Kelly through counsel hereby moves for a new trial on supplemental grounds. Okay. All right. So it goes on to say certificate of service, and we see it's Bonjangles. Okay. So let's continue. All right. Let's get into it. All right. So this is what he stated. Introduction. Defendant's trial was engulfed by irrelevant and excessive bad character evidence that added little to the jury's assessments of whether defendant committed the charged offenses. Indeed, the 6-week trial was compressed overwhelmingly of uncharged bad act evidence that served no legitimate evidentiary purpose, which is a lie from hell. This woman is batshit crazy, ape crap crazy. Sorry, no disrespect, Mama K. Okay, but this what lady is crazy. Okay, let me just remove myself off of this screen. Okay, all right. It goes on to say, with the court's blessing, the government subjected the jury to a mass of repugnant conduct for the primary purpose of depicting defendant as contemptible sexual deviant. The government defended the introduction of the evidence as relevant to the means and methods of the enterprise, with narrowly a word of Rule 403 considerations. For reasons argued in defendant's Rule 29 motion, the government's evidence of an enterprise was insufficient as a matter of law, which we know to be false. They proved their case just without a shadow of a doubt. I mean, like, what are we talking about here? Okay. It goes on to say that this case was not about an enterprise. It was about the conduct of one man who the government sought to punish for his alleged history of mistreating women. As such, the mountain of bad act evidence offered in the prosecution was nothing more than inadmissible propensity evidence, because defendant was forced to defend against dozens of uncharged claims of abuse and sexual misbehavior, much of it lawful, albeit unpalatable for some. Defendant was stripped of the presumption of innocence and denied a fair trial. But that is not all. Defendant was denied effective assistance of counsel when his attorneys failed to file adequate pre-trial objections to the introduction of the mass of overly prejudicial promiscuity evidence and routinely failed to lodge timely objections to some, although not all, of the damning bad act evidence. In sum, defendant's trial was little more than a reenactment of the one-sided docuseries Surviving R. Kelly, which several of the juries had viewed before stepping into the courtroom. It is a wonder that the government did not simply offer the docuseries into evidence. With this backdrop, defendant was powerless to defend against the charged offenses for which there were viable, even winning defenses. Defendant was denied his constitutional guarantee of a fair trial where the jury heard excessive, minimally prohibitive evidence of contemptible conduct that was introduced solely to inflame the passion of the jury and punish the defendant for decades of unchecked bad behavior. Relevant facts. Okay. Hope you guys are doing okay. I'm trying to run through. It's just 14 pages. We are still waiting on the government to respond, but now we know that this is it for Bonjean. So I'm telling you guys, it's going to be a little bit later till we hear from the government because now they have all of what they were waiting on. Okay, I didn't think they wanted to respond until Bonjean did this. Now we're in the waiting game for real. Okay, relevant facts. In the 2 months preceding the start of defendant's trial, his defense team was forced on fighting one another and preoccupied with, y'all hear that? They were fighting each other and preoccupied with litigating a cruel hearing on account of his attorney's disabling conflict of interest. Not surprising. Defense's trial team wasted valuable time and resources focused on this side circus rather than preparing a strategy for defending the case. Yikes. At the defendant's request, this court granted an extension for the filing of motions in limine until July 23rd, 2001. Okay. On July 23rd, 2001, the government filed a whopping 55-page motion seeking to admit a heap of prior bad act evidence. Defense counsel filed no motions in limine. Incredibly, defense counsel failed to prelude any uncharged bad act evidence that was produced as part of the government's 3,500 materials. On July 30th, 2021, defense counsel filed a written objection to the government's motion in limine regarding the introduction of prior bad act evidence largely on timeless grounds. The response contained a general objection to the evidence as ultimately with no meaningful relevancy, objections, or Rule 403 analysis. Okay, inexplicably, defense counsel did not seek a continuance of the trial to investigate these alleged surprise witnesses, but merely asked the court to strike them. Okay, and it goes on to say, at a final pre-trial hearing, defense counsel concluded that he did in fact know who the other bad act witnesses were and was familiar with their allegations. Now, defense counsel concluded that he was in possession of all 3,500 material and had received supplemental 3,500 materials from government. Now, on August 6, 2021, defense counsel filed a 2-page supplemental opposition to the government's motion to admit other bad act evidence. Throughout trial, defense counsel filed a handful of letters objecting to the introduction of certain bad act evidence. Those objections were largely overruled. The record does not seem to reflect objections to much of the uncharged bad act evidence offered by the government. Argument. Defendant was denied a fair trial when his jury was swamped with a mass of minimally probative, cumulative, and unduly prejudicial other bad act evidence, some of which was admitted without objection in violation of defendant's Sixth Amendment guarantee of effective assistance of counsel. With virtually no limitations, this court permitted the prosecution to inundate the jury with excessive bad act evidence, mostly under the theory that the evidence was relevant to the means and method of the enterprise. Okay, give me just a second. I'm just going to refresh the docket to make sure we're not missing anything. No, we are not. Okay, all right, let's continue. The means and method justification for the introduction of a copyist. Hold on, y'all. Okay, sorry, y'all. Okay. Oh yeah, amounts of bad act evidence is gravely flawed because the government's theory of an enterprise is flawed. Child, girl, she's stupid. Where the enterprise consists of nothing more than the purported sexual misbehavior of the defendant, unconnected to the activities of a discrete enterprise. The means and methods relevance justification is meaningless. As argued at length in Defendant's Rule 29, girl, we know it was 56 pages. The government failed to prove that defendant was distinct from the so-called enterprise. No matter how much repellent evidence of sexual indiscretions or abusive behavior the government accumulated against the defendant, the fact remains that it was the defendant and the defendant alone who engaged in those affairs, wholly disconnected to the affairs of a distinct enterprise. By characterizing defendant's decades-long history of abusive conduct toward women as an enterprise, the government not only avoided statutes of limitations, but was free to introduce any unkind or abusive act of a sexual or non-sexual nature as evidence of the enterprise, conveniently avoiding the rule against the admission of propensity evidence and the limitations set out in federal, and y'all see that, okay. Notwithstanding, this court was still obligated to conduct a meaningful Rule 403 analysis, which it failed to do. Rule 403 authorizes the exclusion of relevant evidence when its probative value is substantially overweighed by the danger of unfair prejudice, confusion of the issue, or misleading the jury, or by consideration of undue delay, waste of time, or needless presentation of cumulative evidence. The United States Supreme Court held in Old Chief that unfair prejudice as to a criminal defendant speaks to the capacity of some concededly relevant evidence to lure the fact finder into declaring guilt on a ground different from proof specific to the offenses charged. Okay, and this is the charge or the act or what have you. The committee notes to Rule 403 explain unfair prejudice within its context means an undue tendency to suggest decision on an improper basis commonly through not necessarily an emotional one. Adversary committees notes on federal, and this is this that courts that follow the common law tradition almost unadmonishedly have come to disallow resort by the prosecution to any kind of evidence of a defendant's evil characteristic to establish a probable of his guilt. Not that the law invests the defendant with a presumption of good character, but it simply closed the whole matter of character deposition and reputation on the prosecution's case in chief. The state may not show defendants prior trouble with the law, specific criminal acts, or ill name among his neighbors, even though such facts might logically be persuasive that he is by propensity a probable predator of the crime. The injury is not rejected because character is irrelevant. On the contrary, it is said to weigh too much crime with the jury and to so over persuade them as to prejudge one with a bad general record and deny him a fair opportunity to defend against a particular charge. The overriding policy of excluding such evidence, despite its admitted probative value, is the practical experience that is disallowance since to prevent confusion of issues, unfair surprise, and undue prejudice. Okay. All right. Probative value is also informed. It's also informed by the availability of alternative means to present similar evidence. Specifically, the Supreme Court has advised that the Rule 403 probative value of an item of evidence may be calculated by comparing evidentiary alternatives, okay, and in that particular statute, okay. Now I'm just refreshing the docket, making sure that we're not missing anything, which again, I really do not think it's going to be anytime soon with the defense just not dropping this. The district court is afforded wide discretion to exclude evidence that is on balance unduly prejudicial, and this is this law, so long as the district court has essentially balanced the I probably said that wrong, y'all see it, I'm trying to rush through this, balance the preferred evidence probative value with the risk of prejudice. Its conclusion will be distributed only if it is arbitrary or irrational. Okay, as set out below, this court did not consensually balance the probative value of certain proffered government evidence that carried an extraordinary risk of prejudice. In some instances, trial counsel failed to object to the introduction of such evidence, rendering counsel's performance objectively unreasonable. Okay, excessive STD evidence. The government charged the defendant with committing numerous racketeering acts in the states of California and New York by knowingly exposing Jane and Faye to herpes. This court repeatedly noted that under its interpretation of the statutes, the government was not required to show that defendant transmitted herpes to Jane and Faye. Mere exposure was sufficient. Okay. As set forth in his Rule 29 motion, defendant quarrels with this court's interpretation of the statute, but assuming our Juno or Gorno, the court is correct. There is little justification for allowing massive amounts of evidence that defendant purportedly spent decades transmitting herpes to numerous women. The defendant's physician, the government presented evidence that the defendant had herpes when he was sexually active with Jane and Faith, that he knew he had herpes during the relevant time period, and that he was treating his condition with a regimen of foul tracks. Both women testified that they had unprotected sex with the defendant, and that defendant did not disclose that he suffered from herpes. This evidence was unrefuted. Accordingly, any additional evidence related to defendant's herpes diagnosis and transmission of herpes to other women was unnecessary. Child, you are an idiot. Okay, she mad because they had substantial amount of evidence pertaining to his herpes. So let that be known for the people in the back that was like, they didn't ever prove he had herpes. So she's saying, yeah, okay, y'all were pushing it. Notwithstanding, the prosecution admitted excessive evidence about defendant's failure to practice safe sex and elicit numerous allegations that defendant transmitted herpes to other women. Specifically, the prosecution presented testimony that defendant, one, suffered from other sexually transmitted diseases prior to his sexual relationship with Jane and Faith. 2, had infected Geronda with herpes. 3, had infected Kate with herpes. And 4, had infected Anna with herpes. The prosecution offered copious amounts of documentary evidence regarding defendant and his partner's herpes treatment and elicit graphic details from multiple witnesses about the symptoms of herpes. The government uttered the word herpes hundreds of times throughout this trial. The evidence was ranked propensity evidence for the reason argued in defendant's Rule 29 motions and above. The government simply failed to show that the so-called enterprise existed so that defendant could expose women to herpes. As such, the herpes evidence is not justified under the catch-all means and methods of the enterprise. Doing a little refresh, you guys, so I can keep you guys abreast, making sure we're not missing anything. Okay. Continue. Where are we at? Moreover, whatever probative value it had was significantly outweighed by its prejudicial effect. Sorry, y'all. Although trial counsel voiced an objection to the admission of Kate's testimony, the record does not clearly indicate that trial counsel objected to the excessive amount of herpes evidence from numerous other witnesses. This failure was objectively unreasonable since there is no possible trial strategy for failing to limit this type of other bad act evidence, which was designed to breed contempt for the defendant. Furthermore, there can be no confidence in the verdict of guilt where it was based largely prejudicial bad act evidence, including excessive herpes evidence. Child B, evidence concerning sexual relations with Aaliyah. Here we go, y'all. The prosecution charged the defendant with 1 racketeering act of bribery for the sole purpose of getting evidence before the jury about his marriage and relationship with Aaliyah. Over defense counsel's objection, this court permitted the prosecution to introduce testimony from Angela, Jane Doe number 7, that she allegedly observed sexual interactions between defendant and Aaliyah in 1991 on defendant's tour bus. This court erred by allowing this highly prejudicial testimony into evidence. Angela's testimony was not relevant under the means and methods theory since it purportedly occurred pre-enterprise. What, girl? This enterprise been going on since the, okay. This court seemed to recognize that fact, but nonetheless concluded that Angela's testimony that she witnessed sexual intercourse between defendant and Aaliyah provided the motive for defendant's racketeering act of bribery. Defendant respectfully disagreed on this point. The prosecution presented testimony about defendant's alleged motive for marrying Aaliyah through Demetrius Smith, who expressively stated that defendant told him that Aaliyah was in trouble and thought she was pregnant. Okay. Smith elaborated that defendant believed that he needed to marry Aaliyah to protect himself from going to jail. Now, graphic testimony from a third party about seeing defendant and Aaliyah engaging in sexual relations added nothing more to the motive than defendant's own admissions and the fact that he married Aaliyah. Whatever probative value Angela's testimony had on this point was substantially overweighed by its prejudicial effect. As such, it was error to allow Angela to testify about her alleged observation on the tour bus 1991. Okay. All right, let me just refresh. Okay, and there's nothing. Like I said, we're probably not going to hear anything until late tonight, especially with them getting this in at 9 Central Standard Time. We're almost done, y'all. Just 3 more pages, actually. Testimony from Addie, Alexis, Kate, Anna, Angela, Louis, and Alex, which is the 2 John Does at the end, Louis and Alex. This court permitted the government to present a whopping 7 additional witnesses to testify about graphic, uncharged, bad act evidence concerning dozens of sexual encounters with the defendant. Apart from Angela's testimony, which concerned sexual conduct pre-enterprise, the prosecution defended the introduction of this evidence under the catch-all means and methods of the enterprise theory, as argued above. You guys, we got 3 more pages, okay? We're almost done with this. As argued above, where the defendant and the defendant alone was the enterprise, the means and methods justification for the introduction of copious amounts of bad act evidence is simply a free pass at introducing unlimited bad act evidence related to defendants' alleged sexual misdeeds and abusive conduct. The circular logic returns us to the overarching defeat in this prosecution, namely that it was a prosecution of defendants' bad character and unpunished sexual misdeeds. It had nothing to with punishing. It had nothing to do, baby. She was rushing to do this, forgetting words. It had nothing to do with punishing. It had nothing to do with punishing or preventing the conduct of an enterprise. Even if the evidence had some relevant purpose, the evidence was accumulated and unduly prejudicial. The jury was inundated with one jarring story after the next of unconventional graphic sex acts, including sexual conduct that many, perhaps most, would consider deviant. Okay. Example, group sex elements of BDSM, which we were talking about that too. And coprophilia. It's like whenever you're like in like they said in a zombie like state or whatever, like a lot of the John Does were making mention of, they were in zombie like states. And some people like to have sex with people that are unfortunately in that kind of realm. When considering this mass of prior bad act evidence cumulatively, its probative value is diminished exponentially as compared to its prejudicial effect. There can be little doubt that the defendant's jury was inclined to ratify past injustice by punishing defendant, even if it harbored doubt about his guilt on the charged offenses. Girl, it was no doubt. Like, child, please, not even a little. The risk of prejudice and confusion was particularly acute, where the trial devolved into a live rendition of the Surviving R. Kelly docu-series. Child, if this lady don't stay off these YouTube streets, with viewing of sexually explicit videos. Oh, I thought they didn't see no videos. Yeah, because they did. Trial counsel objected to the introduction of testimony from Addie in a letter dated August 26, 2021, filed under seal. But the record does not seem to reflect that defense counsel specifically objected on 401 or 403 grounds to all of the Form A4 mentioned prior bad act evidence, with the exception of Angela, but only as to her observations about defendant's conduct with Aaliyah and not as to her own sexual experiences with defendant. Okay. Trial counsel's performance was objectively substandard, where it failed to adequately object to the introduction of this damning evidence. Trial counsel offered no written response to the prosecution's motion to allow this evidence and made no meaningful arguments at the final pretrial conference on these matters. Since trial counsel claimed that he was surprised by the proposed other bad act witnesses, he was in no position to make cognate and comprehensive arguments objecting to this unduly prejudicial evidence. Even when giving another opportunity to file more fulsome objections, counsel failed to do so. No trial strategy justifies this objectively unreasonable performance, okay? And that's the law, all right? Got one more page, you guys. Inexplicably, trial counsel affirmatively introduced other prior bad act evidence. For example, okay, trial counsel opened the door to testimony concerning defendant's prior criminal prosecution in Illinois. Now, if you guys remember reading the transcripts, the judge asked, okay, remember the sidebars that we were privy to, okay? The sidebars that we were privy to show where Judge Donnelly was like, hey, if you go into this, you're going to open this door, okay, about his prior testimony. I mean, about his prior situations and what he has going on. And she kept doing that repeatedly, all right, okay? But after we finish with this, we're going to actually go to the lawyer, you know, and we're going to hear what they have to say about this. But we're going to finish this. We got one more page, okay? Defendant's prior criminal prosecution in Illinois State Court related to sexual exploitation of a child. No sound trial strategy justified telling the jury that the defendant had been previously prosecuted for crimes nearly identical to those charged in the instant case. Now, the defendant was prejudiced by his attorney's failings, where a reasonable probability exists that this court would have excluded such of the prosecution's proposed bad act evidence if it had been challenged competently. There can be no confidence in this verdict of guilt where the jury was overwhelmed by bad character evidence. All right, goes on to say, admission of graphic videos depicting sex acts. Woo! Remember, they said that we didn't have any evidence. Y'all remember that, right? Oh, it looks like we did have some evidence in there. And let's see what was said in regards to this evidence that we had that we didn't have, that everybody say that we didn't have. Okay, let's see what they said. Okay. Defendant was further denied a fair trial when this court permitted the introduction of graphic pornography and still photos. There you have it, folks. Okay. All right. Including but not limited to, group sex between the defendant, Alex, and Dominique. Do y'all hear this? Okay. This is what the jury saw. That everybody in their mama on the other side, okay, was saying that where are the videos? They didn't see no, but yes, they did, people. Okay, and you're hearing Bonjean said right here. Let me get a rewind. Rewind. Graphic pornography and still photos involving group sex between the defendant, Alex, which is a man. Yeah, which was a man, a little boy at the time. And Dominique, who did not even testify in these proceedings, and graphic videos involving Anna, including a video depicting, oh my gosh, coprophilia, meaning that this young lady was out. She was out, probably high as a kite or unconscious of some kind of value. That's disgusting. And y'all, they saw this, okay? They saw this in the videos. Trial counsel objected to the introduction of these videos. I'll bet blatantly. Again, for the reasons set forth in counsel's letters to this court and for the reasons identified, Supra, this evidence was not relevant to any means and methods of an enterprise. Since there was no enterprise, girl, you're an idiot. Whatever probative value it had was substantially overweighed by its prejudicial effect. One cannot imagine a more prejudicial piece of evidence than these videos, which added very little to the testimony the jury's heard. Girl, what are you it backed up what they said, if anything more. She's an idiot. Conclusion, y'all. Here we go. Gearing down to the final page. In conclusion, in light of the foregoing, defendant's convictions must be vacated and a new trial ordered. Oh, that was it. You're an idiot. This woman is Looney Tunes, okay? This woman is crazy, all right? But you know what? I was doing my due diligence, doing my research because I'm getting ready for tonight, okay? We're still awaiting for the government to respond. Now, you guys, we will be hearing from the government real soon, and I'll be back. I don't care if it's at midnight, okay? I will be back here to read what they say. However, I will say this in regards to all of this, what we just read, okay? All right. I was doing my research, okay? And I was watching the lawyer, you know. Let's check out and see what he had to say in regards to one thing in particular, okay? All of this mumbo jumbo. I have another clip, but I'm going to share it once we hear from prosecution, okay? But let's see what the lawyer, you know, has to say about this overall.
Why I do think this is going to allow, he's not going to win the judgment of acquittal. No. But his better chance might be in the appellate courts if an appellate judge sees it differently than this judge does. But this has all happened pre-trial already. All of these arguments have already probably been made, and the judge has already ruled against them, so it shouldn't be a surprise. I think R. Kelly's best chance at winning any of these pre-trial or post-trial motions, post-conviction motions, is his motion for new trial based on ineffective assistance of counsel during voir dire and not picking a fair jury. I think that's his really only chance to win, and that would be for a new trial, not an acquittal.
I think you're probably right.
I don't think he's going to win. I'm saying that's his best chance.
It's his best chance. Right. I'm glad you said that, because it's extremely difficult to say you hire a lawyer, you pay a lawyer, now you're not happy with the lawyer. You chose. He's not wasn't a public defender you were forced to take.
Right. They made strategic decisions and you lost. You can't go back and now second guess all of the strategic decisions and get another shot at it, a second bite at the apple, as they say.
You heard that, right? Yeah. Now, don't come in here now and say, oh, gee golly, Williker, we should have did this a different way. No. You get what you get and you don't throw a fit. In the words of my wonderful, wise husband, you get what you get and you don't throw a fit. You can't say now, oh, the counsel was ineffective because you didn't win. However, on the contrary, and that's what I be saying, what I was saying to the opposing side. Oh, so now Y'all are against Mechanic the Mechanic. That's what y'all were calling him, but now y'all against him because he didn't get you guys a win. But before, y'all was just all for it. Okay. So yeah, child, please. Okay. So we're gonna wrap this up because we're still underway, waiting on the prosecution. Okay, but this tells you right here that I'm trying my best to keep you guys abreast as to what's going on. What we just read was the final piece to Bonjangles and the defense's team strategy and motion. Okay, remember they submitted two different motions. The first motion was acquittal, and as you guys heard from the lawyers, good luck with that. Like, not trying to be funny or whatever, but seriously, good luck with that, because I even said that. I was like, girl, bye. Okay, if anything, you will be more so going for the new trial. Okay, so this is what we're hearing, the final component of the piece. This is the reason why she asked for the extension, y'all. These little 14 pages that we read is the reason why she asked for the 1-day extension from yesterday to today. Okay, now that we have this final piece, now the government can fully respond. That's the reason why we hadn't heard from them. And to be honest with you, I knew we weren't going to hear from them anytime soon, because in the back of my head, I was like, we're still waiting on the defense to finish. Now that they're finally finished, it's going to be the wee hours for the government to respond. Okay, we freaking me hours until the government responds, because we're now getting the information when it comes to the defense. Okay, so we are still waiting, you guys. I report here. I'm trying my best to post onto my wall. I didn't get to that quickly this time, because when I refreshed it, I saw it was updating. I was like, let me just go live. And that's what's going to happen here, you guys. Okay. I'm trying to get everything to you guys as it comes in. I didn't even get to do my welcome in with you guys, so I do apologize to those that are coming in. Let me go ahead and go through the spew of it. Okay. All right. Welcome, you guys, to WhitneyD TV. You guys did not get to place your city in the chat, but you still can do so. Make sure that you guys keep it cute so you won't get the boot. Okay. Subscribe to the channel if you have not done so already. Like this video and share this video. Okay. Now, while we're getting into joining the channel, I want to give a good shout out. Let me see if she's still in here. Okay. First off, let me see if she's still in here. Let me see. We had a new member, and I got something new that I'm starting for you guys. Okay. New member alert. Shouts out to Shade. Now, if you guys want a preview too, I shouted out all my members today with my with the little video. So if you did not get to catch it, go and head on over to my videos, check it out. I shout all my members out, and we had an additional one today, and she made sure to get in the comments, baby. She was like, Whitney, I joined today. So shouts out to Shadi. And anytime anybody joins, you guys can be fully prepared to get that rendition, okay, of Cookie. Okay, give her cookies, baby. I want to see all the cookies in the chat. Okay. All right, you guys, that is it for this video. I am seriously going to keep you guys abreast. My husband already know. I was like, look, okay, I got to be on call. Look, I'm tired, okay, but that's all right. I am here to report the facts, the evidence over emotions over here, okay? So I pray you guys are doing okay. Let me get into the chat. I said hi to a few of you guys, but let me see. We got some new faces in the building. Hey, Amber Bamber. Hey, Roslyn. She said, hey, honey, bunches of oats. Hey, that's what I say. Hey. Yes. Yep. Oh, wait, I got to refresh this. I don't know why it's going all slow for me. I'm sorry. Hey, sweet and humble spirit. Hey, it's Quaisha. Hi, everyone. I hope you had a beautiful day. I did. I'm waiting on the government. Hey, Mary, I'm sorry I wasn't watching the chat, just listening. Oh, okay. You're talking to somebody. Okay. All right, you guys. So I'm not going to make this long and drawn out. I want to be able to come back to you guys when we hear back from the government. Okay. So thank you guys so very much for tuning in to another installation of R.KELLY Tales. Okay. Now, as we always do, and as we always wrap up in R.KELLY Tales, you're killing me with this.
Y'all killing me with this. I can't help.
Robert.
You're killing me, man. This ain't not about music. I'm trying to have a relationship with my kids, and I can't do it. Y'all just don't want to believe the truth. You don't want to believe it.
At this point, we briefly pause the interview to give Kelly a moment.
Man, y'all killing me with this. Y'all killing me with this. Y'all killing me with this. Y'all killing me. Y'all trying to kill me. Y'all killing me with this. Y'all killing me with this. Y'all killing me with this. Y'all killing me with killing me, man. Trying to kill me. Killing me, man. Trying to kill me. Y'all wanna believe it? Trying to kill me. Killing me, man. Trying to kill me. I hope this camera keep going. Stupid R.KELLY. Fight for my life. Stupid R.KELLY. Do it. Stupid R.KELLY. Fight for my life. Stupid R.KELLY. Do it.
What up, you guys? Whitney D here with Whitney DCD, and we have merch. Check it out in the description box down below.
I'm Whitney. Keep it cute and get the boot.